So we've started recording and we're waiting for more of you to join in before we officially begin. In the meanwhile, like I said, you can write in the chat box. So Abhishek says that he has not been introduced to CPC yet. So that's great. I hope that it will be a good introduction. This session will help you understand just a little bit better what CPC is all about. Anybody else, would you like to tell us where you're joining us from? Have you studied CPC before? And also, please, if my audio is breaking or my video is breaking, most of you are in touch with me, so you can just text me and let me know that you can't hear me or you can't see me. I am relying on you to do that. Okay. Yashta says good evening. Hi, good evening, Yashta. Okay, Achintya. Hi, Achintya. So good to see you again. Achintya says his interest in teaching and learning of law brings him here. And Merry Christmas and happy festivities. Merry Christmas to you too. Merry Christmas to everybody. The fact that you're spending your Christmas Eve with me, that means a lot. And I really hope that you gain something valuable after today's session. Hi, Tamanna. Thank you so much for being here, Achintya. Achintya is from NLU Delhi and he's extremely, extremely smart. So you can maybe get in touch with him to clarify some concepts. I'm glad that he's here. So Tamanna, where are you joining us from? Okay. I got your message, Abhishek. That's awesome. So everybody, you can just keep on writing in the chat box. I believe we can officially begin with the session. This is being recorded, which will be uploaded on Oliveboard's YouTube channel later. So you can refer to it later. You can share it with your friends who have maybe missed it or maybe could use it. Before we begin, I hope you can see my screen. I've shared the PPT with all of you. If you can see my screen, can you just write yes in the chat box? Hi, Shrey. Great. Thank you, Achintya. Thank you, Shrey. So I always say this in all of my sessions. I want my sessions to be interactive, to be conversational, not a monologue, not a dialogue. We are here to exchange knowledge, and I'm not here to just, give you things to cram. So let's not make it like that. So Oliveboard has come up with some judiciary courses. They have actually covered all the Hindi-speaking states. MP, Uttar Pradesh, and you can just check out their courses. I'll also share the link with you in the chat box. They are, so, I always say this, and I've done this. I've also prepared for judiciary before. I've sat for tele-judiciary services. And if nothing else, the preparation in itself allows you to accumulate and understand so many diverse legal concepts that no matter what you choose to do in your legal profession, the preparation is always going to help you. Even if you don't end up cracking the exam, even if you don't end up sitting for mains or anything like that, you can still gain so much just by preparing for judiciary. And I can say that from personal experience. I cleared the prelims. I could not sit for mains for some personal reasons, and I do plan on giving it another shot when the circumstances are right. But I can tell you from personal experience that when you study, when you prepare for judiciary, it opens your mind up to so many different applications of law, so many different concepts that you would not really have studied like that or thought about like that. And those concepts, they help you a lot in your practice, in your legal profession, no matter what you choose to do. And so you can, maybe check out these courses, or you can share the link with your friends who are preparing for judiciary. So Oliveboard is giving 50%, flat 50% off on their judiciary courses if you use the code XMUS, and this code is valid only till 26th of December. So there's not a lot of time, so you can avail this opportunity. Now let us officially begin with today's lecture. Today we are going to talk about CPC. Civil Procedure Code. And why we are talking about CPC, or trying to understand the why of CPC or other things that we have to cover in today's agenda, is that because CPC is one of the most important procedural law that will stick to you no matter what you're doing in the legal profession. If you are a legal consultant, if you are a law student, if you are studying for your LLM entrances, if you want to sit for judiciary, if you want to even just sit for LLB entrance exams. I'm sure most of you are already in law school, so you must have given your LLB entrances. Even then, you, before you even enter the law school, you know what CPC is, and that's how important it is. It is all about the procedure that has to be followed by courts when it comes to civil cases. And that procedure is very, very important to understand. So, when you're trying to, I said this before, I'll say it again. When you get into property or something like that, they say that there are three golden rules when it comes to a good property, and that's location, location, location. And when you're studying law, especially for entrances, especially for judiciary, or even when you're trying to understand what the bare acts mean, it's mostly about procedure, procedure, procedure. Now, there's a significant difference between substantive law and procedural law, and I'm sure that all of you must have at least some idea about what the difference is, and we'll discuss that in the later slides. And I would love to hear what your take is. And like I said, let's make it very interactive. You can write in the chat box if you have a question. You can also raise your hand. You can just unmute yourself and start talking to me. So I would really, really urge all of you to ask as many questions as possible, to stop me where you think that you will not be able to understand the topic. If you are not clearing your doubt then and there, just stop me and ask me. If you think you can wait till the end, just wait till the end for the questions, and we will discuss all of your questions one by one. The idea is that please just do not just sit there and listen. Have a conversation with me. That way you'll be able to gain more out of this than expected. So our agenda for today's session is to understand the why of CPC. Why was CPC enacted in the first place? We will also touch upon the concept of jurisdiction. Now, since it's a very short lecture, we'll not be able to delve deep into each of these concepts, but we will understand where are these concepts located in CPC, what are they broadly telling us, and how to, eventually read up more on that, study more on that, try to understand how practically this concept is implemented in real life. And then we're going to talk about the hierarchy of civil courts, hierarchy of courts that are dealing with civil cases. And finally, we'll talk about the meaning and origin of civil suits. So these are the topics that we will be covering today. Now, why CPC at all? Why Civil Procedure Code? You can find the answer in the preamble of the bare act. Now, if you have your laptops open or your phones with you, or better yet, if you're in your study room and you have the CPC bare act, I would urge you to open the act and have it right next to you, so you can at least locate and identify what is where and where you have to study more. And remember this, guys, the primary source of law, the primary source of understanding what a particular law is all about, is the bare act. And I saw in the chat box somebody said, Tamanna, I think, said that she's preparing for CLAT 2023. Now, that is amazing. And you're preparing and you're here. So you and everybody else and the bare acts will stay with us in our legal profession throughout our lives, because we always have to refer to what exactly the law says, and nothing is above that. Nothing can be changed in that. That is what the law is, the way it is. So we have to understand how to read a bare act, how to interpret statutes, and all the judgments, all the case laws, all the commentaries, all the guidebooks, everything else that we have. They are trying to explain to you what the bare acts are all about. So what is the primary source here? the Bare Act. Always read it, understand it, and reread it, understand it again. Because you'll realize it later, you've read it so many times and you'll read it again, and every single time you'll understand it differently, one way or another. You'll have another layer of understanding of it. So read it again and again. The preamble of a Bare Act is the very first thing that you see once you open the Bare Act. So when you open CPC and you check out the preamble, it doesn't say that it is the preamble, but we call that section the preamble. Like we have the preamble to the Constitution, we have preamble to every Bare Act. And it says that CPC was enacted to consolidate and amend civil laws. Now, just to give you a brief background, historically speaking, and I won't get into the details because frankly they're boring, but we must know the background a little bit to make sense of this. So until 1859, we all know that we were under British rule till 1947, and under 80, in the year 1859 till then, we had different laws that were operating in different provinces, in different presidencies, in different localities and areas of our country. So there was no one uniform code or uniform law that prevailed throughout the country. And then there were a lot of events happening. In 1857 we had the first revolt, and in 1858 we had the High Courts Act enacted. In 1861 there was another act, before that, the High Courts Act, under which the High Court was established in different presidency towns. And then there were provincial council acts also, in which different courts and provincial councils and presidency states were also established. So what happened in 1859 was that all of the power was transferred to the Queen, and East India Company. The Government of India Act was also enacted, and East India Company transferred the authority to the Queen of England to basically rule over the entire country. So under that, the other laws were also um, somehow amended, and new laws were enacted. And in 1859 we had the first CPC of sorts. It wasn't perfect, and there were a lot of amendments that were made to it, but it was the first code that was enacted to make sure that there is some uniformity, at least in presidency states. And then after that, an amendment was made, which was in 1877. And then, several amendments and several changes and several political issues later. In 1908, we had the CPC, which we are following till date. And that CPC was to consolidate and amend civil laws. Now, before we move any further, can anybody tell me, you can just unmute yourself and tell me, or you can write in the chat box, what do you mean by civil? So what are, civil laws? I keep saying that it's for civil purposes, but what is civil? You can write in the chat box. Hi, Pranjal, it's great to see you. So people who've taken litigation basics with me and are here, and people who've graduated, people who've already studied civil procedure code, you also know. So you can just tell me, what do we mean by civil procedure code? Or civil law, actually, not civil procedure code, civil law. I can't see any answers, guys. I won't move on until and unless you tell me, at least one of you. So what's the difference between civil and criminal? Why are we focusing on civil? What are civil rights? What are civil suits? What is the meaning of civil, essentially? So Abhishek says that court cases that involve disputes between people or businesses over money or some injury to personal rights are civil cases. Absolutely on point, Abhishek. I'll just fine tune that a little bit. Yashda says civil laws deal with private matters. Yes, Yashda, you're also correct. So guys, all the laws, if you go back and try to understand why were laws enacted in the first place, All the laws are to govern and regulate different relationships that individuals have with each other and individuals have with their state, with their government. So, there's a public law, there's a private law, and there's civil and there's criminal. So, civil is a private law. Civil laws regulate relationships between individuals, between businesses, organizations, anybody that can be legally identified as a legal person. Once you study jurisprudence, you'll be able to understand that there's this fiction where you can be a legal person. Even if you're a company, you are a separate legal entity recognized as a legal person in the eyes of law. So, all of these, the relationship between them, when it comes to money matters, when it comes to property matters, when it comes to marital matters, matrimonial matters, when it comes to breach of contract, anything like that, uh, you are talking about civil laws, just to put it very, very simply, and to give you an idea. So civil laws, for different, we have different substantive laws. Now I will want you to tell me what you think is the difference between the substantive law and the procedural law, because that also becomes very important to understand CPC, Civil Procedure Code, which is a procedural law. So you need to understand, why is it a procedural law? What is a substantive law? Why is this not a substantive law but a procedural law? So if you're preparing for any exam, or even if you're just trying to understand what CPC is, you have to know what is the applicability of CPC, what is the effective date. Effective date of any where act, any law, is the date which is notified by the government. It's either in the act itself or it is to be notified later, and those government notifications then make that the effective date. Now, even though CPC is 1908, it's a code that was drafted in 1908. It became effective from January 1st, 1909. And, these are some questions that are asked again and again in competitive exams also. So you should pay attention to that. And where is CPC applicable? So as per section 1 of the code, CPC is applicable to the whole of India except Nagaland and tribal areas. Now, before this, before 2019, it was also not applicable in Jammu Kashmir. Jammu Kashmir had its own civil procedure code, just like Jammu Kashmir has its own penal code, which is Ranbir Penal Code. So before 2019, Jammu Kashmir also was excluded from CPC being applicable. The Uniform Civil Procedure Code that we have for the rest of India, Jammu Kashmir was exempted. But now Jammu Kashmir is also a part of the territory which is under the jurisdiction of CPC. So the Civil Procedure Code applies to Jammu Kashmir also. Now, another thing that becomes important for you to understand is that this is how you correlate current affairs, the allied laws, and the allied events that are happening with what your law says. So you must know, especially if you're preparing for some entrance, you must know that what was the reason why Jammu Kashmir was before 2019 excluded and after 2019 included. That was because there was a Jammu Kashmir Reorganization Act that was enacted in 2019, which came into effect from 31st October 2019. And then there was an order, I think it was called Jammu and Kashmir Adaptation of Central Laws Order 2020, which became effective from 31st March 2020. And that made Indian Penal Code, Civil Procedure Code, CRPC, which is a Code of Criminal Procedure, and other major laws, central laws, applicable to the state of Jammu and Kashmir. So you must know all of that as well. And section 1 will tell you about the applicability and the effective date. Now, what is the general layout of CPC? It's very, very wide. It's so big, and there are so many times, like even while practicing, so I've been practicing in Delhi High Court and other district courts in Delhi and Gurgaon for the last almost 4 years now, and I still have to refer to CPC again and again to know just exactly what that order says, what that rule is all about, what that section is all about. You can never be too sure. So yeah, sorry, I got distracted by the chat box. I'll answer the question later, Tamanna. So, what is the layout of CPC? Now, the CPC is divided into 12 parts, and no matter how many times you read those parts, you'll have to read them again. And that is not to say that, it's very difficult or you'll not be able to make sense of it over and over, but because it's a procedural law, so you have to refer to that. Now, again, I am referring to the term procedural again and again. So get ready. I'm going to ask you this question next. What is procedural law and what is a substantive law? So since it is procedural, and I'll explain it later, you need to refer to it again and again and again. And this happens with substantive laws also, but in procedure, it happens more often. So there are 12 parts in total with 158 sections. There is one schedule of the act also. Schedule has 51 orders, which all of these orders have different rules within those orders. So at first, it will be very, very daunting. It will be very scary to go through the entire Bear Act. But I would suggest when you're trying to understand CPC especially, and when you don't really know how the practical functioning of the code goes, you must start with this first section. Not even the first section actually. Start with the preamble of the Bear Act. Start with the statement of object and reasons. Start why exactly it was enacted, then go section by section. Section 1 will tell you where it is applicable, what is the effective date. Section 2 is all about definitions. So all the words, all the terms that are used in that Bear Act, you have to, if you don't know the definition, you will have to look at section 2 to understand the legal definition of that particular term. You can't just Google it. You can't just say that this is what I understand. You have to refer to section 2 to understand what that term actually means, and then you go ahead in a sequence. So try to read the Bear Act in a sequence at first, and then try to correlate, okay, this order is related with this section and this means this, and so on and so forth. We won't get into the details right now. Then the first schedule carries 51 orders, I told you. Before, the act, yeah, there was an amendment, I think in 1999 or 2002, where the 5 schedules, there were actually originally 5 schedules to the CPC, and the 4 schedules were repealed after the amendment, and the first schedule remained, thankfully. So there's only one schedule which carries the orders and the rules. Now the orders and the rules tell you just exactly how something has to be done. For example, section 26 talks about institution of suit. And what is the institution of suit? That is also something we'll discuss today. And order 6 will talk about how those pleadings are to be presented. Order 7 will talk about plaint. Order 8 will talk about written statement. So you can connect section 26 with order 6, 7, and 8 like that. So that is something you can do once you are very, you've read it again and again. So the first step is to read it. Then there are 8 appendices. 8 appendices carry different forms. So, how a plaint should look like, how a written statement should look like, how an affidavit should look like, how a summon should look like. Summons are court notices that go from on behalf of court. So how do those documents look like? So sample formats are sort of given to you in the appendices. So this is the general layout of CPC. And then, of course, we have the fact that it is a procedural law, and it is to enforce rights and liabilities, and there are also amendment to the rules that can be done. Now this topic, this particular bullet point is something I'll discuss with you in detail, but before that, I've been going on and on about this. Can you just write in the chat box or unmute yourself and talk to me? What is the difference between substantive law and procedural law? Very basic question. So Yashita has said substantive law tells what the law or code is, for example, IPC, and procedural law discusses the process to administer and apply the law, for example, CRPC, CPC. Awesome. So this is very comprehensive. Thank you for that, Yashita. Yashita has saved all of you a lot of, research and time. So just like she said, there is a substantive law. Substantive law will tell you just exactly what are your rights, what are your duties, what are your liabilities, what constitutes an offense, what are the ingredients that should be there for an offense to be established, so on and so forth. So Indian Penal Code will tell you all about the offenses, and offenses are against the state, generally speaking. So Indian Penal Code will talk about the offenses. And then we have Code of Criminal Procedure, which will talk about if an offense is committed, then how the police are supposed to act, what are the duties of the police, how the police officers are to be appointed to a case, how the arrest has to be made, how the bail can be granted, what happens once the case reaches the magistrate, and what are the things that the magistrate should be following, what are the duties, what are the rules, what are the orders, what are, so on and so forth. So that then becomes a procedural law, to put it very simply. Similarly, in civil cases, we have a lot of substantive laws that tell us, okay, these are our rights and these are our liabilities and our duties, and we can enforce them. We can go to the court if these rights are infringed upon, if these duties are not fulfilled, we can approach the court. Now, what are these substantive laws in civil cases? They can be Transfer of Property Act. Transfer of Property Act tells you how a property is to be transferred, to put it very simply. Then there is breach of contract. So we have Indian Contract Act. So how the contracts are to be drafted, what is a valid contract, what is a void contract, what are your rights when it comes to, having a contract or entering into a contract, how will you be eligible, all of those things are in Contract Act. So Contract Act becomes substantive law. And how are you to enforce your rights? So for example, I enter into a contract with Yashta, and I have failed to fulfill the duties that I had promised in that contract. Yashta then has a right to go to court against me and file a case for breach of contract. So she can go to the court, and once she goes to the court, what the court has to do, what procedures and the rules and the orders and the regulations that have to be followed by the court are given under Civil Procedure Code. Okay, so that is the difference between substantive law and procedural law. And since CPC is a procedural law, it does not create any rights, it does not create any liabilities. It only tells you how to enforce the rights and how to enforce the liabilities, and also the rules that are given. So in every order, I told you there are a number of rules. There are 100 rules, 90 rules, so many rules. Okay, and there'll be too much to understand. So I would suggest that you go one by one and you understand what is the practical implementation of these orders and these rules, and then you go ahead. So, there's so many rules, but every court has the authority, the High Court especially has the authority to make their own rules. So if you go to any High Court's website, High Court of Delhi, High Court of Punjab and Haryana, you'll be able to see a section that says court rules or rules and regulations or protocols to be followed or directives or guidelines. So you'll be able to see them. Once you check them out, you'll be able to know that, okay, they'll tell you what is the jurisdiction. We'll understand what jurisdiction means later. They'll tell you how the plaint has to be filed, in how many days written statement has to be filed, how many adjournments can a party take, everything, what dress code has to be followed, everything. So every High Court has the power to amend these rules. You can check that out under section 122, 125, 129 of the CPC. So they have the power to amend the rules and to make their own rules when it comes to how they want to follow the procedure. but those rules should be in consonance with the CPC. So CPC is the parent act, it's the parent code, and the rules that are framed under the code have to be in alignment with the main code. So you can't just say, so according to CPC, if one court has to listen to the opposite party before going ahead with the next stage of the case, they have to send a notice to the opposite party, which goes from the court, which is called the summons, and say that a case has been registered against you and you have to come and defend yourself. You can't make a rule that says that we don't need to send summons at all. If a case has been registered, we can just go ex parte from the first date of hearing itself. If I frame a rule like that, if I say I am a judge at Delhi High Court and I make a rule like that and I publish it on the website, that rule will not be valid because it's not in consonance with the CPC, what the Code of Civil Procedure actually says. So I hope that is clear. Now we are moving on. Can you write in the chat box if that is clear or if there are any doubts till now? If it's clear, just say yes. If you have any doubts, you can just unmute yourself and ask. Come on, guys, I'm waiting. Okay, thank you, Pranjal. If I'm going too fast, if you want me to repeat anything, feel free to interject. Thank you, Kirti. Kirti has also said yes. Okay. Tamanna has asked, do you also have a course for CLAT? Yeah, Tamanna, you can check out Oliveboard's website. They do have a course for CLAT. I will share the link with you in a bit. Anya says clear. Awesome. So we were just getting warmed up of sorts. Okay. Now, as you can see on your screens now, we are moving on. We are trying to go a little deeper into what all we just discussed. What is jurisdiction? What is the hierarchy of courts? What are the different kinds of judges? What do you mean by a civil suit is something now that we are going to discuss now. Now, as you can see on your screens, if there is any discrepancy when it comes to a special law and what the CPC says, then the special law will prevail. Now, what is a special law? I'm sure you guys must be aware of National Green Tribunal or RERA. RERA is the Real Estate, Dispute Redressal Authority, or let's say State Commission, Consumer Dispute Resolution Commission, or NCLT, National Company Law Tribunal. So are you aware of these tribunals? Have you heard of these tribunals? Can you write yes in the chat box if you have? Okay, awesome. So all of these tribunals, they are created under special laws. They are created by enacting some special statutes for some specific reason. If you talk about consumer courts, which are the district commission, state commission, then they are enacted under Consumer Protection Act. So they derive their power from that particular statute. If you talk about National Green Tribunal, then National Green Tribunal gets its power under the Environment Act. If you talk about family courts, they get their power from Family Court Act. If you talk about NCLT, NCLT gets its powers from the the IBC. Okay, IBC is the Insolvency and Bankruptcy Code. So all of these special courts, the tribunals, have been into existence because of some statutes, and these statutes are special laws. They are enacted by the parliament with an intention to, first of all, reduce the backlog and the burden that is on the other courts, on the civil courts, on the district courts, on the high courts. So they want to reduce their workload, their burden, and also because they are such specific reliefs that need some special attention and special laws are enacted. So there are some particular tribunals dealing exclusively with such matters. So these tribunals are under special laws. Now, if there is any clause in the special law, any provision in the special law that explicitly excludes the jurisdiction of the civil courts, then the civil courts will not have jurisdiction. Now, what is jurisdiction? Jurisdiction is the authority or the power that is given to a court to adjudicate upon a matter. To adjudicate means to determine the rights of the parties that are before that. So if I have jurisdiction to entertain a matter, that means that I can pass a judgment on the facts and circumstances that are presented to me by the parties that have come before me asking for some relief. So I have the power to give them that relief. I have the jurisdiction to act in accordance with law. If I don't have jurisdiction, I cannot pass a judgment. So if a special law categorically says that civil courts will not have jurisdiction to entertain this matter, then civil courts cannot be approached. So if it's an environmental issue, if it is a matter of some, about pollution or about any other issue that pertains to the Environment Act, then I must approach the NGT, which is a National Green Tribunal. If it pertains to, real estate, so I have, say, bought a flat, but the builder has not delivered it to me, I cannot directly approach the civil court or the district court. I'll first have to go to RERA. If it's a family matter, when it pertains to, say, divorce, or some issue when it pertains to will or succession or inheritance, then I will have to approach the family court. So Section 8 under Family Courts Act, Section 79 under RERA, and Section 29 under NGT Act, they categorically exclude the jurisdiction of the civil courts, which is your normal district court. We'll understand the hierarchy of the courts in the next slide. But before we do that, you have to know that civil courts and district courts entertaining civil matters can also only listen to those matters upon which they have jurisdiction. If you read Section 9 of Civil Procedure Code, you'll be able to see that the civil courts have the authority and the jurisdiction to entertain matters that pertain to civil disputes, but excluding if their jurisdiction is impliedly or expressly barred. So when you're reading these sections, when you're reading the terms express or implied, you also have to go deep into what these terms mean. So when we talked about Family Courts Act or NGT Act or RERA, there are specific provisions that explicitly say that civil courts will not have jurisdiction. There's a bar on jurisdiction when it comes to civil courts. And then there are some other acts which imply that there is a bar on the civil court's jurisdiction. They don't actually have a provision that says it, but it is implied. For example, if you read different provisions of Consumer Protection Act, you will understand that the District Commission, the State Commission, the National Commission, they do have the powers that are ordinarily given to a civil court under Civil Procedure Code. And that's how, a civil court or a district court should not be approached when it comes to consumer disputes. So it's an implied bar on jurisdiction. It's not directly there, but you have to understand the intent of the parliament in enacting that particular law, and then trying to understand whether there is a bar on jurisdiction or not. And similarly, there are other concepts that you have to understand when you're trying to understand jurisdiction. So under Section 10 and Section 11 of CPC, we talk about sub judice matters and we talk about res judicata. Sub judice matters are under Section 10, which means that if a case between the same parties on the same issue is already in progress, the proceedings have already begun in a different court, then that case cannot be presented again before some other court, because again it will lead to multiplicity of proceedings. There's no point wasting court's time. If one court already has been listening to that particular case, you don't need to waste another court's time to understand just exactly, what is going on in that case. So there is a bar on jurisdiction then under section 10. If a case is already registered under some other act or in some other court, then you cannot have the same case in a different court between the same parties on the same issues. Similarly, res judicata, when we talk about res judicata in under section 11 of CPC, we are saying that if a case has already been decided by one court, the judgment has been pronounced, you cannot go to another court of the same level and say that, no, I don't like this judgment. So these are the facts between the same parties. So you also listen to this case and you tell me what you think about it and you pass another judgment. You can't do that. That means res judicata in the simplest terms, that once a case has been decided by another court, then you cannot have the same case before another court with the same facts between the same parties. And that is also an express bar on jurisdiction. I'll take all of your questions. I understand you must have some questions, and these topics are very widely covered and there's a lot to learn about these topics. And I'm not going into case laws, I'm not going into specific definitions right now or any other details because we don't have that kind of time. But if you need any clarification, please collate your questions and ask them at the end of the session. We'll discuss it further. So you have to understand, if the court is already barred to exercise jurisdiction which is implied or expressed, which is categorically written in a legal provision, or which is understood by the intent of the parliament that this court will not have jurisdiction, then that court cannot entertain that matter. If that matter is entertained and if the decree or the judgment is passed by that court without jurisdiction, then that decree or that judgment becomes a nullity. Nullity means that it is not enforceable, it is not a valid judgment. Okay. So if you want to learn more about jurisdiction, what it means, what the CPC says about jurisdiction, please check out sections 9 to 12 in your CPC and 15 to 25 of your CPC. So when you talk about section 15, you will be able to say that, you have the authority. Anybody can sue anybody. Okay. We all have a right to sue. We all have a right to file a case. How the case begins is by the presentation of plaint. So that is also something we'll discuss. That's a civil suit. Okay. And where we have to file our case, section 15 categorically says that we have to go to the court of the lowest grade first. So this is where hierarchy of courts come into play. You have to know what is the court of the first instance that has original jurisdiction, that has subject matter jurisdiction, that has territorial jurisdiction, pecuniary jurisdiction, and only approach the lowest court first and then move ahead. And again, this is done with the object, with the intention to save the court's time, to make sure there's no multiplicity of proceedings, and to make sure that there are different allocation of duties and there are different rosters of judges dealing with different kinds of cases and not the same kind of case being dealt with all the grades of courts. Okay. So what are the kinds of jurisdiction? There can be subject matter jurisdiction. Subject matter depends on what exactly you're asking from the court. What is the relief that you're praying for? So broadly speaking, subject matter can be civil or criminal, very, very broadly speaking. So in civil cases, you can only approach certain courts, right? You can go to the civil court, you can go to the district court, you can go to the high court, you can go to the small causes court, you can go to, other tribunals dealing with some special reliefs if you're asking for special laws, but you can only approach those courts. In case of criminal cases, you have to approach the magistrate. So since we are not discussing CPC, CRPC and IPC today, we will not go, into that, but you can read about it. We go to magistrates. There are different grades of magistrates also. There are different grades of criminal courts also. So it depends on the subject matter. Then it depends on territory also. So territorial jurisdiction, it depends on the geographical limitations. So if, for example, my property is in Gurgaon and I have a dispute with the property, say, somebody else has trespassed on my property, or I have gotten illegally, somebody has tried to demolish my property and I want to approach the court to seek remedy for that property or their specific performance. Let's say that I entered into a contract pertaining to the property that after this and this day, on payment of this much amount, I'll get my property, but I have paid the amount, but I have still not gotten the ownership of the property. So the court that I can approach to seek some reliefs in terms of that will be the court within whose territorial jurisdiction my property lies. Okay, and of course, these can also be found in section 16, 17, 18, 19, 20 of CPC, where they talk about different kinds of jurisdiction. So you have to understand what is territorial jurisdiction. So in terms of immovable property, territorial jurisdiction is of is of paramount importance. So within the geographical limits is territorial jurisdiction. Then you have pecuniary jurisdiction also. Now there are different courts that have the capacity or the eligibility to entertain cases that are valued up to a certain amount only. For example, the civil courts, the civil judges in Delhi, district courts, can only entertain matters up to that pertain to release that are asking for up to rupees 3 lakhs. Okay, if it's beyond that, then you have to go to the High Court. There are some courts that have unlimited pecuniary jurisdiction, which means that they can entertain any case with any upper limit of the amount. And how you value your suit is also something that you'll have to, go through Court Fees Act and Valuation of Suits Act to understand better. But the idea is that whatever you're asking for, if I'm asking if it pertains to a property, then what is the value of the property? If I'm asking for recovery of money, then what is the amount of the money that I'm recovering or I'm seeking to recover? If it's a commercial dispute, we also have Commercial Courts Act now. So we have to understand the pecuniary jurisdiction. So what is the amount of, until which a court can entertain a particular matter? So, like I told you, in Delhi, 3 lakh is the upper limit for civil courts, civil judges, and then you go to the High Court. Similarly, there are other states. It depends from state to state. What is the pecuniary jurisdiction, the rules and everything, they change from state to state. So in Allahabad, for that matter, the High Court of Allahabad has only appellate jurisdiction. So they can only listen to appeals. They cannot have original cases, original suits in the High Court. So the city courts, the city civil courts, they have unlimited pecuniary jurisdiction. They can listen to any, they can entertain any matter for any amount of money. And then you have original jurisdiction also. Original jurisdiction is where the case was introduced or pled for the first time. So if it is to be filed for the first time in a court, then that court should have original jurisdiction to listen to that case, to entertain that case. Appellate jurisdiction means that the court has the authority or the power to listen to appeal from the order or the judgment that was passed by a lower court. Okay, so these can be tricky, these can be confusing, but you have to know what jurisdiction is, what it means, if the court has jurisdiction or not. Because if the court does not have jurisdiction and it is challenged and it is proved that there is no jurisdiction, then the case will be dismissed in limine and you'll have to go and file the case in the proper court. Okay, so it becomes a very important topic. It becomes a preliminary issue that is discussed. In fact, after you file a case, the first hearing takes place, and in the first hearing, the judge has to decide whether the case will be admitted to be moved forward. And in that, jurisdiction is one thing, one major thing that the judge will look at. If you don't have jurisdiction, your case will be just rejected. Now, just relating um, the hierarchy to what we have covered up until now. We've talked about different courts having different jurisdictions, what jurisdiction actually means, what are civil courts, and what do you mean by civil laws, what is the difference between procedural law and a substantive law, and all of that can be tied down to hierarchy of courts. Again, this varies from state to state, but very broadly telling you, and we are only talking about civil cases, civil courts that entertain civil matters. We have not included magistrates here. So at the very lowest strata, you have Moonsif Court. Now, Munsif was a term that was used in the British era again, and there are a lot of terms in court that you'll come across that are carried forward from the British era. So Munsif Court is the court which is of the lowest stature. So there is Munsif Court, or there is Provincial Court of Small Causes. There is Presidency Small Causes Court also. So over here, the judge is called District Munsif or Junior Civil Judge, and there is only a certain kinds of cases that these courts can entertain, and only up to a certain amount of money, up to the limit of a certain amount of money. Now, how to understand that? Presidency Small Courts Act, yeah, Presidency Small Causes Courts Act of 1887, I think. Just go through that, you'll be able to understand what these courts are. So they entertain very specific kinds of issues. For example, for cases that are up to the limit of 2,000 rupees or 5,000 rupees, they are not supposed to entertain 44 kinds of cases that are explicitly laid down in the second schedule of the Presidency Small Causes Court Act. So you can go through that. They cannot entertain cases where they are supposed to pass orders of injunction. They cannot entertain cases that pertain to transfer of immovable property, and they cannot entertain cases that are about breach of contract. So very, very small basic cases, like the name suggests, only those cases can go to Municipal Court. Then after that, you have your you have your principal junior civil judge. Now these terms also keep changing from state to state. So there is a junior civil judge, then there is a senior civil judge, then there is a district judge and additional district judge, and which constitute the district court. So we often think that it's just the district court and then the high court and then the Supreme Court. It's not like that. Within the district court, there are different civil judges which are of junior division or senior division, and then you have district judge, which is the head of the entire district, and then you go to high court where you have your judges and chief justice. So district court will have jurisdiction over the entire district, and the civil judges will have jurisdiction up to a particular amount of pecuniary jurisdiction, like we just discussed. For example, in Delhi, you don't have civil judges that will be divided into senior or junior, but whoever is a civil judge, whoever is managing a civil court, can entertain cases that are up to the limit of 3 lakh rupees. Similarly, in Ahmedabad, if you go to Gujarat, High Court of Gujarat will have appellate jurisdiction, and the city courts will have unlimited pecuniary jurisdiction to entertain matters. In Bombay also, the civil courts will have unlimited pecuniary jurisdiction. So it depends from state to state what are the terms that are used, what is the pecuniary jurisdiction. But this is the broad hierarchy, that you have civil courts which have civil judges, junior, senior, then sometimes they're called grade 1, grade 2, grade 3. Grade 1 is of course the senior one, then below that comes grade 2, then grade 3 of civil judges, and then you have finally district judge. They also have assistant or additional district judges, and then district court. And then you come to high court. High court is in every state, as we know. So they have jurisdiction over the entire state. They have a chief justice, and then they have other judges. So for example, in Delhi, we have 45, Delhi High Court, we have 45 sitting judges. And in Supreme Court, again, we have 34 sitting judges and one Chief Justice of India. So this is the broad hierarchy of the courts that you need to remember. Again, they keep changing from state to state, and the judiciary exams that take place, they are for the admission of these, filling out the vacancies for junior civil judges, at lower courts, at the courts of first instance, majorly, which are district courts, and then the courts that are covered within the district court. And now we talk about suits. But no, we don't talk about Suits season 1, a very, very popular show. We talk about what suits actually mean in the legal sense. So any volunteers, anybody, would you like to tell me what are civil suits exactly? They're not defined anywhere in CPC. You can just write in the chat box, you can unmute yourself and tell me. What are civil suits? So of course, a civil case is nothing without a civil suit, right? We've understood which court to approach, what are different kinds of jurisdictions, but approach with what? What is a civil suit? Anybody? No volunteers? Okay. So you can take guesses also, it doesn't matter even if you are not 100% correct or not at all correct. It's all right. This is all a part of learning, right? So what is a suit? A civil suit? No definition has been provided in CPC, as I just told you. Yashta has written civil suits are more compensation oriented. Yes, so they are, again, they're pertaining to a property or money or a matrimonial dispute. But you have to understand that they begin the institution of civil suit, as we discussed in section 26 of CPC. They begin with the presentation of a plaint. Now, what is a plaint? Just like a plaint is the very first complaint that you make to the judge, to the court that has jurisdiction, to the court where you're approaching, that these are the facts. This is what has happened to me, and the facts should be in a chronological order. So this happened first, and then this happened, and then this happened, right up to the moment where you are forced to approach the court. So these are the facts. After the facts, you tell them what is the cause of action. Cause of action means the reason, just exactly what happened that triggered you to approach the court and ask for whatever you're asking for. So you have to tell them the cause of action. For example, if my property is being illegally demolished, then the illegal demolition or the threat of illegal demolition is my cause of action, and that is why I'll be going to court. So I'll have to specify that in my plaint. Then after that comes the prayer. Prayer clause tells you just exactly what is the remedy or the relief that the court can provide you, and then you end it with an affidavit. An affidavit is a sworn affidavit that goes along with the plaint, that says that whatever has been stated in the plaint is true and correct to the best of my knowledge, and nothing material has been concealed. So you're basically saying under oath that you are not filing a frivolous case just to waste the court's time or just to take revenge on the opposite party. It has to be very well thought out and very well planned, and you must be very, very sure that you are approaching the court, so you must have a case. So section 26 of CPC can be understood better to really know what a plaint is. And then orders 6 and 7 also tell you what should be in a plaint and how the case has to be proceeded with. This is the very first step when it comes to civil suit. So your plaint, your presentation of plaint is basically institution of suit, starting of the civil case. And then what happens after that is that your case gets registered. So order 4 and rule 2 tells you that registration is mandatory. So once you approach the court staff or at the filing counter itself, they will register the case, which means they'll put it on the court's register. They'll list it for a particular day for a hearing, and you'll get the registration number. And then summons are issued. So the court notice that goes to the other party that a case has been filed against you, along with the copy of the case, is called the summons. Section 27 and Order 5 deal with summons. And then after that, there's appearance and the case moves forward with the defense. So Order 8 and Order 9 tell you about written statement, which is to be filed by the opposite party as a defense to just exactly why the court should not punish them or why the court should not believe the plaintiff. So you have the defense. So this is what broadly a civil suit is all about. We understood what civil procedure code is, why it was enacted, and within that we understood what is jurisdiction, what are the different powers of the different courts to entertain different kinds of cases, so different types of jurisdiction. And then finally we came to the smallest bit, but the major bit, which was civil suit. What exactly is a civil suit and what happens once a civil case has been filed? And this is very, very limited right now. I'm not telling you all the stages, because for that we have to go through the entire code to understand it in depth. Now we're going to discuss your questions. If there are some questions that remain even after the session, you can approach me. You can reach out to me on Instagram, YouTube, LinkedIn. My handle is Law Chakra by Sanya, as you can see on your screen. So you can always reach out to me with your questions. Now I'm going to stop presenting and I'm going to check out what questions you've asked in the chat box. So Yashta has asked, civil suits are more compensation oriented. Could you please shift to the previous slide once more? Okay, previous slide, 1 second. Yashta, I'll just ask you if this is the slide that you were talking about. 1 second. This slide. Is this the slide you're talking about, Yashta? Or the hierarchy one? Okay, this one. So you can make note of this. These are the 4 very, very small steps that take place once a civil case is instituted, which is known as a civil suit. And it starts with the presentation of plaint. But yes, the definition of suit is not given anywhere. So I hope this helps. Awesome. Thank you, Yashta. So again, we are officially done with today's session. There are questions, I'm sure there are. Anything you'd like me to clarify right now? We can take another 5 minutes for this. Somebody was asking me about the CLAD course, and if you also want to check out the judiciary courses, I'll just share the link of Oliveboard courses with you, and you can just check them out and use the Christmas code, the special code, to avail 50% off. So if there are no questions, you can just write no in the chat box. If there's anything you'd like to discuss, please feel free. I know we covered a lot in a very short period of time. And there are too many layers to those topics, but I hope at least you know where to look for, what to study and what not to do when you're reading the bare acts, especially when it comes to CPC. Okay, so guys, if there are no questions, please write no in the chat box. Okay, Pranjal has asked, can you tell us about how to go through the bare act? Yeah, Pranjal, so like I told you, it's a lifelong study when you're studying the bare act. Always read the preamble to understand just exactly what is the reason for that act or that law to be enacted in the first place. So read the preamble. If there are any terms that you cannot understand, first you go through the section 2 or section 3, usually in different bare acts, which tell you the definitions. So you go through the definitions. If you still can't understand what those terms mean, you look for judgments where those terms have been defined or interpreted by different courts of the country. So the idea is that you understand what it means. You don't just read it or ratify it just for the heck of it. You really try to understand what those terms mean, what that section mean, because at the end of the day, the laws are enacted in order to regulate relationships between different parties and between the state and the subjects, which are the individuals or the other organizations. So how that happens, how that has to take place, what are the rights and liabilities, how they are enforced, is something you should always have at the back of your head, that how that is happening. And until and unless you understand that, you keep reading. And then another tip is to read it in a sequence. Don't just jump from one section to another. And I know it happens in a lot of legal provisions, that they would say that just like it has been mentioned in this particular section of this act, and this is what we are following, the definition of this will be in accordance with the definition of this in this act. So that happens. In that case, you can just go through those provisions to understand just exactly what this provision is trying to say. But other than that, don't jump to sections. Don't just think that this is not important, section 1 is not important, it's all about just where the act applies and what was the effective date, what am I going to do with it, so I'm not going to read it. Don't do that. Read every section in sequence, take it slow, take it bit by bit, and try to interconnect one provision with another. Because at the end of the day, even when we're drafting contracts and we're trying to get into some understanding, memo of understanding or association with each other, we start with definitions, we have different clauses that are going towards one main goal, one end goal, right? Similarly, it's with the bare acts. So everything is in a sequence. When the parliament enacted that law, they had something in mind, they have created a structure. So follow that structure, understand the object, understand what each section means and where it is progressing. And once you've done it once, then you start going through different judgments also to understand how complicated provisions have been interpreted by different courts. And that is also another way of you trying to understand how practically law is applied to facts. So I hope that helps, Pranjal. There's no way out. There are no shortcuts, honestly, especially with CPC. CPC is, it's like very, very dangerous. Okay, Achintya has said, thank you so much, Sanya. Oliveboard is a great platform. Thank you, Achintya. Check out the judiciary exam section and recommend. In fact, just a couple of hours ago, I was speaking with a friend of mine who are considering preparing for judiciary without quitting their ongoing job. Online platforms like Oliveboard are really good for working people. Exactly. So Oliveboard is a very, very good brand, and they have top-notch quality courses. Right now, I think they've come up with foundation courses which are dealing with the prelims. They are going to come up with courses for mains also, and then they have onboarded a retired judge who will actually also help the registrants and the people who have enrolled to practice interview with them. So that is also going to be very helpful. So Abhishek has said, thank you, ma'am, for such an informative session. Like all the other sessions you do, I really learn a lot from you. Hoping to attend more such sessions in the future. Thank you so much. That really, really means a lot. I am trying to simplify this, and I'm trying to connect it with the practical functioning of the course and the practical implementation of your knowledge, because I understand how it can get when you're studying it for the first time, and I've done it in law school. It gets very difficult, and I want to make it fun, I want to make it interactive, and I'm glad that you guys are so supportive and always there. In fact, I'll be taking a series of lectures for Oliveboard throughout the month of January. And please follow the social media channels to know more about those sessions, and you can register for them and avail as much benefit as you can. because no matter how much knowledge you gain in the field of law, it's never going to be enough, and you're constantly learning, unlearning, relearning everything. So attending these sessions and interacting with me, asking your questions and trying to supplement your the knowledge that you've gained in your law schools, it's amazing. Merry Christmas to all of you, happy Christmas Eve, and thank you for spending this time with me, and I hope that you found it productive. I'm going to stop recording now.